Hey people, it's Niles talking. I'd like to thank one of my followers for posting about this story. So this is from CNBC. Nestle and Cargill win child slavery case at Supreme Court. The Supreme Court reversed a lower court ruling that had allowed 6 men to sue Nestle USA and Cargill over claims they were trafficked as child slaves to farms in the West African nation of Ivory Coast that supplies cocoa to the two giant food companies. Justice Clarence Thomas, writing for the majority, said the U.S. Court of Appeals for the Ninth Circuit had erred in allowing the suit on the grounds that Nestle and Cargill had allegedly made operational decisions in the United States. The 6th individual has sued under the Alien Tort Statute. And I just want to point this out. Clarence Thomas is obviously the only black judge. And this is where I always say, having a black anything doesn't solve anything. Because he is a black judge and he sided against the child slavery victims from Africa. Let's keep going. The Supreme Court on Thursday reversed a lower court ruling that allowed 6 men to sue Nestle USA and Cargill over claims they were trafficked as child slaves to farms in the West African nation of Ivory Coast that supply cocoa to the two giant food companies. Justice Clarence Thomas, writing for the 8-1 majority, said the U.S. Court of Appeals for the Ninth Circuit erred in allowing the suit on the grounds that Nestle and Cargill had allegedly made operational decisions in the United States. Thomas said the 6 plaintiffs, who are from the nation of Mali, improperly sought to sue under the Alien Tort Statute for the conduct that occurred inside the United States. Thomas also said the plaintiffs had failed to establish that the conduct relevant to the ATS occurred in the United States, even if other conduct occurred abroad. Paul Hoffman, a lawyer for the men who sued, said during a media briefing on the decision that obviously were disappointed by the ruling, but also called it the narrowest possible loss we could have had in this instance. He noted that a majority of justices in the decision agreed that corporations can be sued under the Alien Tort Statute. Hoffman said it is also our intention that we will file an amended complaint, which he said believes can satisfy the court standards for making a claim under the ATS. He said Nestle and Cargill control every aspect of what goes on in the production of cocoa in Ivory Coast, and they should be held accountable for abetting a system of child slavery. The 6 men who sued claimed that those companies aided and abetted child slavery because they knew or should have known that the farms were using enslaved children. While neither company owns or operates farms in Ivory Coast, they had bought cocoa from them and also provides the farms with technical and financial resources in exchange for exclusive right to their crops. The plaintiffs claimed the companies had economic leverage over the farms but failed to exercise it to eliminate child slavery, Thomas noted in his opinion. A U.S. district court had originally dismissed the lawsuit after the Supreme Court ruled the Alien Tort Statute does not apply extraterritorially. While the plaintiffs were appealing that dismissal, the Supreme Court ruled that the court cannot create new causes of action in the ATS against foreign corporations. The Ninth Circuit Appeals Court then ruled in Nestle and Cargill case that the Supreme Court's ruling did not foreclose judicial creation of causes of action against domestic corporations. The Ninth Circuit also ruled that the plaintiffs had properly claimed the ATS applied in the cases because financing decisions originated in the U.S. But Thomas, in his opinion, wrote that nearly all of the conduct alleged in the lawsuit occurred in Ivory Coast. He also wrote that a claim of general corporate activity in the United States is not sufficient to link to conduct abroad for a claim on the ATS. To plead facts sufficient to support a domestic application of the ATS, plaintiffs must allege more domestic conduct than general corporate activity common to most corporations. A Nestle spokesman in a statement on the ruling said child labor is unacceptable. Slave labor is unacceptable. That is why we're working hard to prevent it. Nestle never engaged in the egregious child labor alleged in the suit, and we remain unwavering in our dedication to combating child labor in the cocoa industry and to our ongoing work with partners in government and non-governmental organizations in the industry to tackle this complex global issue, the spokesperson said. Access to education, improving farming methods and livelihoods are crucial to fighting child labor in cocoa production. Addressing the root causes of child labor is part of the Nestle Cocoa Plan and will continue to be a focus of our efforts in future. Cargill, in a statement, said the Supreme Court's ruling today affirms Cargill's analysis of the law and confirms this suit has no basis to proceed. Regardless, Cargill's work to keep child labor out of the cocoa supply chain is unwavering. We do not tolerate the use of child labor in our operations or supply chains, and we're working every day to prevent it, the privately held company said. We will continue to focus on the root causes, including poverty and lack of education access. Our mission is to drive long-lasting change in cocoa communities, and to lift the families that rely on cocoa for their income. Well, I hope you enjoyed that. I'm going to leave this article and others in the description. Please comment, rate, share, and subscribe. If you want to support this channel, leave my GoFundMe in the description. If you want to follow me on Instagram, I'll leave that there as well. If you want to buy one of my t-shirts, I'll leave that there as well. Peace.